Trial will likely give Kenosha, a former factory town on the shore of Lake Michigan, more attention than it has ever received.
Yeah. For more insight and context on the proceedings, we're joined by Jamie White. He's a trial attorney and the founder of White Law. Jamie, good morning to you. Thanks for being with us on Morning Rush. Let's talk about jury selection. How difficult is that to get an impartial jury with so much national attention?
It's very difficult. I don't even know that you'll get an impartial jury. I mean, people are going to have so much knowledge about this case, and they do have knowledge about this case. The key is trying to identify people that acknowledge they have information, but are willing to set that information aside and follow the law. And that's a difficult challenge. I think they'll get there, but, we've seen this before, but there's not going to be an impartial jury. People are going to come into this process with preconceived notions.
Definitely. So Rittenhouse was technically a minor when he shot 3 men. So how heavily do you think the judge and jury will weigh that into their consideration?
I think it's going to be a huge factor. The young man, his behavior, in my opinion, my personal opinion, is just unbelievably wrong. However, anytime you see a 17-year-old man in Kenosha, Wisconsin, he's going to look and sound a lot like the members of the jury pool. And there's going to be a reluctance to send him away for the rest of his life. I suspect there's going to be some mitigation by the jury or even a potential last-minute deal by the prosecutor to avoid an acquittal.
One of the most interesting headlines leading up, of course, has been that Judge Bruce Schroeder determined that the 3 men Rittenhouse shot can be referred to as arsonists, looters, and rioters, but they cannot be called victims. This is his standard. He does this all the time. How unusual is that, though, across all courts?
So this is a big deal. The idea, it's very common that defense attorneys will come forward and ask that, quote unquote, not be referred to as victims. The most common is complaining witness, right? Because by calling them a victim, you arguably plant a seed in the head of a jury. So there's nothing unusual about that piece. What is unusual is that the judge is going to arguably allow the other folks to be called looters and rioters. And that, to me, is extraordinary and arguably opens up an appeal. If the evidence suggests that they were looting and rioting, then that could be something that could be dealt with. But to make this decision ahead of the trial, I think is biased and troubling. And I think, again, opens up the possibility of an appeal in the event that this doesn't go the way that people think it will.
Jamie, is there evidence that they were looters or rioters?
Not that I've seen in the public sphere. I mean, obviously the people have their case and the defense has their case, but, I think that it's going to be very difficult to prove that to any sort of level where, the Court of Appeals would feel comfortable allowing this to stand. I just don't see it. I mean, there certainly is evidence that they were there, and there certainly is evidence that there was looting and rioting, but to put this on these particular individuals, I think, is a stretch without a necessary founding.
Right. So is there a precedent then for self-defense cases involving a minor? And does that give one side any sort of legal advantage here?
So the self-defense case is obviously going to be the crux of this issue. He's already admitted that he killed people on the phone with friends and with authorities. So the only issue at this point in time is, was he legally in a position where his use of force was justified? And this is going to be problematic, I think, for the defense. It's not required that you are in a lawful situation to enact self-defense, but it is certainly going to be weighing in the heads of the jury. And here we have a 17-year-old boy who was in possession of a weapon that he was not legally allowed to possess in a state where he didn't live, protecting property that he didn't have any affiliation with or the property owners. So I think at the end of the day, it's going to be very difficult for them to pose a credible self-defense case. I mean, you can't go into a bank robbery, kill somebody who is in the middle of your bank robbery and claim self-defense. And I think that when we have all the factors that I just described, we have a young man that was just clearly breaking the law. And to suggest that the consequences of you breaking the law killed somebody but you were going to claim self-defense, it's a stretch. It is definitely it's their Trojan horse, and that's what they're going to go with. But it's a stretch.
You laid it out nicely. Very difficult case to make. Jamie White, appreciate you being with us this morning. Thanks.
My pleasure. Thanks for having me, guys.